My lady, there's been a proliferation of bundles.
Yes.
I hope they've all made their way to you.
Some of us have amalgamated them. We're online as well, electronically. So I think you can proceed.
Thank you very much. I'm aware, of course, that I have applications for extension of time and to rely on fresh evidence, but I wonder whether you will permit me to go straight to the merits of the case, because in our submission there is an important point of principle which may affect the way the court looks at those applications for extension of time.
Certainly. Well, the merits can certainly come into part of the relevant considerations on an application, both for an extension of time and to adduce fresh evidence. Take the course that you would like, but our provisional views, very much subject to any views that you and Mr Eardley have, is that you can by all means address those applications in the course of your submissions. We don't propose to make any rulings on those applications at this stage. We will consider all of the applications together and the full merits, reading the material de bene essay as we have indicated that we would. So if that's a sensible way forward, then let's just take it all in one fell swoop.
Thank you so much.
Yeah.
And I hope the brevity of my address does not undermine the potency of the submission. At heart, we suggest that the approach taken by His Majesty's Solicitor General is incorrect. Of course, sentencing practice in the criminal courts informs the process by which a civil court approaches the exercise of committal for contempt. But that process is not a direct mirroring, as he then was, Lord Justice Leggett said, at best in quadrilla, it is a useful guide. And one can understand why a civil court would wish to take clear precautions before committing someone into custody. However, on review, the tests we suggest are somewhat different. The Criminal Court of Appeal, as your ladyship observed in the case of Watson, but which in any event is well understood, is a court of review with its power derived from Section 11 of the Criminal Appeals Act 1968. Yes. That power is untrammelled, save for by the requirement that you may substitute a sentence that you think should have been imposed. But of course, procedure and practice is such that primarily the test is manifestly excessive or wrong in principle.
That's not in the statute, is it?
It's not in the statute.
That's convention.
Exactly. And that has allowed the fact that it's not in the statute but is by convention, the development of what are called the Bernard principles, which is loosely those principles, and the authorities are conflicting, but those are principles that govern the circumstances in which someone who has a deterioration in health may apply either to this court or to the Secretary of State for clemency or earlier release. However, in the civil courts, the appeal against the order is simply an appeal against the order and is governed by the usual principles, helpfully set out in Breen, but again, of course, well known, that the order below was wrong or unjust because of a procedural or other irregularity.
And you're just relying on wrong?
Exactly.
Yep.
And Lord Justice Leggett, again as he then was, seemed in quadrilla to resist the importing, at least wholesale, into the civil law of sentencing approaches from the Criminal Court of Appeal. Because he says the circumstances in which a sentence may be appealed as excessive, brackets, or unduly lenient, are limited.
And that's paragraph? Can we just make sure everybody's please got their telephones switched off? Thank you. Yes.
That is quadrilla at 85.
Thank you.
However, he goes on to say, if, under usual principles, it is made out that the order was wrong, then the court would either impose such sanction as it thought fit or remit the matter to the original court for rehearing. So the question, therefore, is, on normal principles, was the decision of my Lord, Mr. Justice Johnson, wrong? And we say it clearly was, but not through any fault of his.
Just help me, if you would. You say that there is a point of principle, and at the heart you say the approach of the Solicitor General is incorrect, and you've sought to identify differences between the appeal regime between the two jurisdictions.
Yes.
And what's your headline point? Where does this lead?
There is no need for this court to examine the deterioration in Mr. Yaxley Lennon's health through the Bernard principles.
Right.
The question is, was there a material issue before Mr. Justice Johnson about which, through fresh evidence, it can be shown his decision was wrong? And again, we say at heart the issue is quite simple, in that before him was a one-page letter from Dr. Cutland Green, which, even by that date, was 5 years old.
There's a 2019 letter. It's a
correct.
one-page letter. It's quite detailed.
It is quite detailed. It is. And that may assist me later in respect of whether ADHD should be considered by this court. So the letter before Mr. Justice Johnson set out that Mr. Yaxley Lennon was suffering from traumatic symptoms. However, that cannot compare, we submit, to the statement of Dr. Connolly, which runs to some 39 pages, properly analyses Mr. Yaxley Lennon's condition as complex post-traumatic stress disorder. But importantly, for this point, diagnoses him as suffering from ADHD. And the effect of that diagnosis is to be found at 1712.
Of Dr. Connolly's report?
Yes, at page, supplementary bundle, page 28.
Yes.
I'm going to avoid, I hope, the bear trap of describing it as solitary confinement. I accept its segregation. Aspects of segregation are likely to be particularly difficult for a person with ADHD due to the need for stimulation, inability to relax, and attentional difficulties. And she goes on to describe how the regime under which he is being held precludes the means by which he can typically regulate his emotions.
Can we see in Dr. Connolly's report an understanding on her part that the appellant was not in solitary confinement?
She sets out, and I think part of the difficulty may have been that the regime changed just before the judicial review proceedings. She does detail the circumstances in which he's being held. And it may be that she misuses the label, but she does have a good understanding of the conditions in which he related to her that he was being held.
All right, thank you. So sentence 2.
Forgive me, I just moved away from it.
My fault.
So there are two effects. One, that the mere fact of being in segregation is difficult for someone in Mr. Yaxley Lennon's position, because he is denied the means by which he can normally regulate his emotions, namely frequent movement and seeking contact with others to talk. And she sets out in what is a very thorough and detailed report how he has managed his life up to this point in terms of being able to deal with the ADHD effects. So, one, he is unable to regulate himself or self-regulate. But two, the interplay between the ADHD and complex post-traumatic stress disorder may mean that it is more likely that he behaves in ways that bring him into conflict with the prison authorities.
What conflict has there been? What are you referring to? Why is that relevant?
He's had his, on occasion, his telephone contact has been circumscribed because of the way he's conducted himself on the telephone.
That's one occasion, 2 occasions?
2 occasions, I think.
Right. Anything else?
No, there are other circumscriptions of his telephone rights, but I can't point to conflict with prison guards, for instance, or prison officers that have been caused by his condition. But the question is this. In her opinion, she says that circumstances, aspects of solitary or segregation are likely to be particularly difficult. And we would suggest that that equates to a more onerous condition.
And that paragraph, that's 1712.
That's 1712.
Yes, thank you.
So Mr. Justice Johnson acknowledged that, looking at Dr. Cutland Green's letter, there could be an effect on Mr. Yaxley Lennon's mental health. And along with other factors, he reduced the sentence he was going to impose by 1/6, 4 months. But he did not have before him this additional factor, which in and of itself means that the conditions Mr. Yaxley Lennon faces are more onerous. Mr. Justice Chamberlain, in the judicial review proceedings at 49, paragraph 49,
Yes.
That's in bundle C at page 77.
Yes.
Whilst saying that it wasn't accurate to refer to the regime as solitary confinement, my Lord accepted that the absence of association with other prisoners has had an effect on Mr. Yaxley Lennon's mental health. Moreover, Governor Marfleet, at paragraph 53 in the C bundle at page 47, accepted that there were clinical concerns related to his ongoing segregation. So we say that there is a demonstrable effect on Mr. Yaxley Lennon from the conditions in which he is being held, and that whilst the court below gave some allowance for that, that allowance appears to have been based on what Mr. Justice Johnson described as a reduction in association, whereas it is clear that when one looks at association describing, as it must, the ability to associate with other prisoners, Mr. Yaxley Lennon's conditions are a complete removal of association. The effect, whilst I say that I don't have to satisfy the Bernard conditions in terms of life-threatening illnesses or similar serious deterioration, it should not be lightly taken that Mr. Yaxley Lennon's condition is described as complex post-traumatic stress disorder and that he is not currently in mental crisis. It is clear from Dr. Connolly's report that what tends to happen for Mr. Yaxley Lennon is being held in segregation contains him and his symptoms, but it is on release he demonstrates behaviours which are harmful and indeed raised questions in those immediately close to him as to whether or not he may seek to take his own life. There are serious, therefore, consequences to the way in which he is being held. It is on the point of deterioration that I may turn to the question of extension of time. It is right that the first mention in the prison records of concerns on his part of mental health deterioration is on the 12th of December, but it's not right for my learned friend, for the Solicitor General, to focus on that date. It is clear that there's a further mention on the 27th of December, and that, of course, in terms of our obtaining a report, it had to be seen that what was going on was not transitory, but indeed represented a consistent decline in his health. And this court may observe that it is not unusual, certainly in the criminal courts, for there to be a similar delay to the period we've seen in this in order to find experts who are able to address these issues. So we say the extension of time arises out of the fact that it took some time for him to cease being able to cope. It took some time to establish that that decline was not transient, and then we had to obtain a report in circumstances where the court knows resources in the mental health facilities are overstretched. The question as to whether ADHD was reasonably discoverable, my learned friend graciously does not seek to resist the adduction into evidence of Dr. Connolly's report in respect of complex post-traumatic stress disorder, but says, well, look, Mr. Yaxley Lennon has always suffered from ADHD, and therefore, under the usual principles, that can't be adduced as fresh evidence. We say, looking at Dr. Cutland Green's, as the court observes, detailed letter, she sets out helpfully that Dr. Leahy, the psychiatrist, had already seen Mr. Yaxley Lennon and referred him to her. Neither of those healthcare professionals had seen that he suffered from ADHD. That is, we submit clear evidence that in fact that condition was not immediately obvious and was not discoverable by the application of reasonable diligence. It took, in fact, those with experience of this issue to recognise that that's what he was suffering from. And so we say extension of time should be allowed, and indeed the report of Dr. Connolly should be admitted in full, because the issue of ADHD is fresh evidence, and it is exactly on point. The question being whether these conditions are onerous, and Dr. Connolly answers that question in the affirmative.
I think sort of the way the case is put against you on this is perhaps more that the late admission of the contempts was made in the weekend before the hearing was due to take place. You had, or rather the appellant had with him, the report, the letter of Dr. Cutland-Green, and everybody was happy to proceed on the basis of that without more.
Yes.
Now, you point to the fact that there's a 2019 report, and I have forgotten, I don't know whether we have any detail of any psychiatric or other treatment between 2019 and 2024?
My lady, no. It's confined to that, and I have to accept that Mr. Yaxley Lennon decided to proceed on that basis. And the best I can do, and that's perhaps a poor formulation to use, but in fact, Dr. Connolly addresses what we suggest might be the underlying problem, in that Mr. Yaxley Lennon is, understandably perhaps, deeply reluctant to talk about mental health issues. He's perhaps not alone amongst men in taking that approach to mental health. But one will see it in her report, both at paragraph 16.4 whatever the rights and wrongs of the belief expressed therein, he was reluctant to address to the prison mental health teams any information about his mental state because he was concerned that it could be used against him. And then later in that paragraph, perhaps the more general position, as he says, and by general I mean he's perhaps not alone in this amongst men and indeed all people. The second reason Mr. Yaxley Lennon gave for not disclosing his mental state was, I see it as a weakness in myself, it's hard to own. The court may take it that presenting as he must have done in court after only 3 days in custody, and being able, as he was, to withstand 8 weeks or so of the regime, it may well be that, whilst it might be obvious to professionals what was going to happen to him, he didn't want to face the fact, as he puts it, it is a weakness, that he was going to be caused serious mental health issues from being in custody. So that is the basis that I can put forward as to why this matter wasn't adjourned below and more detailed reports obtained. But if I'm...
And just to contextualise, so we have the application for an extension of time, I think, of 3.5 months.
Yes.
And is it right, just to contextualise, for no other reason, the current release date is the 26th of July?
Yes.
Thank you.
A comparison is often drawn to, an imperfect comparison is often drawn to breach of a criminal behaviour order as a guide for a court sentencing or committing in civil proceedings as to whether the correct approach was being taken. We say simply this, that it is perhaps an irony that had he been sentenced as a criminal, Mr. Yaxley Lennon would have had available to him the reductions in sentence that are prevalent through Operation Safeguard, but also the possibility of home detention, curfew. He would, in short, had he been sentenced as a criminal, already have been out. I cannot directly take that point. I acknowledge the authority of Westcott and Westcott.
Well, that's very realistic. Obviously, these submissions go to grounds F and G.
Yes.
Do you pursue them?
No.
What about A?
No.
Thank you.
I have to accept, and I'm sorry, the authority of Hallam is in the bundle, taking up a lot of space, to make the point that I'm wrong. I
So
put
there
it
are really
there.
three points here. Yeah. And they're the ones you've helpfully focused on this morning.
My lady, yes.
Thank you.
My lady, I said that I hope brevity didn't undermine the potency of my application, but that is the point. He is being kept safe by the authorities in segregation, but being kept safe is making him ill, and more ill than Mr. Justice Johnson could have foreseen on the basis of the information before him. And we invite this court to interfere with that order to reduce the sentence imposed.
Been very clear, very helpful, Mr. Williamson. Thank you very much indeed. Mr. Buckley, do you follow? Anything to add?
No, my lady.
No. Andrew, do you want to ask anything?
My lady.
Yes, Mr. Adley.
Yes, my lady. I'm grateful for the indication that grounds A, F and G are not pursued. But what I propose to do is just say something about the legal framework for appeals of this nature, and then I'll take the remaining grounds and in order and deal with the extension of time, fresh evidence points in the context of each ground.
Yes.
My learned friend is right to point out that this case falls not under the Criminal Appeals Act 1968, but the CPR 52 approach. Where I part company with him is his suggestion that there is a material difference of the sort he suggests, namely that the principles he's referred to about the limited circumstances in which a court may look at post-sentence deterioration do not read across to contempt. But we say they do. And I can demonstrate that from the authority of Breen, which is at tab 9 in the bundle.
Thank you.
Authorities bundle.
Yes.
Can I begin at paragraph 16 and 17? Paragraph 16 starts on page 159. Lord Justice Coulson says, an appeal like this, and this is an appeal under the civil procedure rules, is not a rehearing but a review. This court will only interfere if satisfied a decision under the appeal is wrong or unjust because of serious procedural or other irregularity. And a decision on sanction involves an exercise of judgment which is best made by the judge who deals with the case at first instance. Now, pausing there, it's significant that it's described as a review because that's exactly what the Court of Appeal Criminal Division describes its function as. Save that, in exceptional circumstances, which it's set out in the Barnard Principles, it will sometimes, as an act of mercy, step outside that reviewing role and look at what the position is now.
This is obviously trite law, Mr. Erdley, and I understand why you take us to it, but to what extent does it help you if there is fresh evidence which the court admits?
If there's fresh evidence, and I don't strongly resist the court looking at that fresh evidence, we say it doesn't bring the appellant into the Barnard Principles or any other.
Well, do you see what I'm trying to say? The obligation, the function of the court to carry out a review is tempered by the fact that if there is to be fresh evidence, it's not only a review as such, because you are in a different position to the position in which the judge below was.
Well, it depends what the evidence is of. If it's evidence as the status quo at the time of sentencing, then, of course, that falls within your review function. But if it's evidence of post-sentence deterioration, which is the real gist of the evidence my learned friend wants to put before you, then that's outside the review scope and into the Barnum principles area. And we say that because both in this court and in the criminal division, the principal function of the court is that of a review of the sentencing, then by parative reasoning, that the same exceptional circumstances which would justify a different approach in the criminal division apply equally here. And if we can just turn over the page, paragraph 17 of Breen, because this approach is clearly stated in paragraph 85 of Quadrilla, which led Leggett, LJ, to say that it followed that there is limited scope for challenging on an appeal a sanction which is imposed for contempt of court as being excessive or unduly lenient. And that's language which tracks very closely the test of manifestly excessive in the criminal division that we say. If we turn back in Breen to paragraphs 6 through to 8, the court there sets out the correct approach to sentencing in a contempt case, citing the Supreme Court in Crossland. And I'm not going to read it out, but you'll see that it follows the familiar pattern of criminal sentencing. You determine seriousness by reference to culpability and harm, that one looks for aggravating and mitigating factors, and then imposes the least penalty possible. But I do place more emphasis on paragraphs 7 and 8, and this is a slight but material difference between the approach when sentencing for crime and when sentencing for civil contempt. Here, Lord Justice Coulson refers to the divisional court in Booz, which he says also emphasised that the purpose of imposing a sanction for contempt is to punish the breach, ensure compliance with the court orders, and rehabilitate the person in contempt. And the fact of compliance with court orders is then emphasised again in the following paragraph, summarising Couturier and Willoughby. An important aspect of the harm is the breach of the court's order, and an important objective of the sanction is to ensure future compliance with the order in question. We say that's very significant in this case, because in this case the judge took the sensible step of breaking the penalty down into a punitive element of 14 months less 3 days and a coercive element of 4 months. In other words, it's in the appellant's gift to shorten his own sentence by 4 months, if only he were to do the things that the judge said he should do, remove his post from social media and take other steps to prevent its dissemination. He hasn't done that. It's a striking feature of this appeal that he remains defiantly in breach of Mr. Justice Nicklин's order. Further publications of his film are occurring every time it's viewed. But at the same time, he comes to this court asking for an indulgence. That's what this appeal really boils down to. He's asking the court to take the exceptional step of reducing his sentence on compassionate grounds, even though a review of the sentence discloses nothing wrong or unjust at all, that we say.
That is a strong forensic point. Is it relevant as a matter of principle that the appellant has not purged his contempt, thus achieving his release? I think it will be at the end of this month.
I think it will be the end of next month. Next month. We say it is because you're being asked to do something exceptional in all the circumstances, and you have to take into the circumstances not only the mental health deterioration, but also the ability that this appellant has to help himself. So we do say it's relevant to the court's exercise of its discretion in this case. So that's the legal framework.
Thank you.
Can I now move on then to grounds B and C? I'll take them together because I don't detect a difference between them.
No, I think we agree with that.
And here my learned friend suggests the reduction that was given by reference to the conditions in which Mr. Yaxley Lennon would be held is insufficient because he's in fact being held in more severe conditions than he envisaged. The first procedural point is that there's no good reason for granting an extension of time on this ground. You can see from the witness statement of Miss Marfleet that the appellant was transferred to Wood Hill on the 1st of November, so 4 days after the order of committal, placed immediately into segregation. His segregation was reviewed on the 4th of November, but not changed. And then it was further reviewed, the first mandatory segregation review, on the 15th of November, and not changed. And you'll see from her witness statements there were really very few options other than to hold him in segregation as things stood. So she makes clear that he was constantly being reviewed and that the authorities were keeping an open mind. But the reality is that the regime under which he was being held had settled by mid-November, leaving him plenty of time to take points in an appeal within the 28 days granted by the court, if it is the case that those conditions are different from what the judge envisaged. But we say in any event these grounds are factually and legally flawed. I'll look at the factual position first, and that involves a comparison of what the judge did anticipate and what actually has transpired. If we turn up the judgment,
Yes.
which is at tab 5 in the core bundle,
Yes.
Paragraphs 87 and 88 set out what the judge thinks prison will be like for this appellant. He makes the Manning point about the high population in adult male prisons and how that impacts on conditions, more prisoners being held in crowded conditions as well as being further away from home. He anticipates that the appellant will be held in circumstances where he cannot associate because of the risk to his own safety. That's at paragraph 88. So we say he had well in mind what prison was likely to be like. And you compare that to what has actually transpired. We have the evidence of the MOJ witness, Mr. Warsman, which is in the bundle C, tab 4.
Yes.
Paragraph 11 there, page 22, he explains that the appellant's being detained in a Category B training standard prison that also has some reception functions. And he describes the Category B training standard as a prison that holds long-term Category B prisoners.
It's really Governor Marfleet, isn't it, who paints the picture?
And then we come to the detailed explanation, Miss Marfleet, which starts at paragraph 59. It's a long and detailed passage. I won't take you through all of it. but she explains the daily routine. 3 hours time out of cell, now recently increased by another 3 hours a day because the appellant has taken up work in the prison. Entitlement to 2 hours 4 times a week.
And I understand that the timing of that previously he had declined to take that up. It wasn't that it wasn't on offer.
That's her evidence,
that
yes.
That he didn't want it. Then he took up the cleaning job.
Yes.
Now,
well,
yes.
painting and decorating, I think, yes.
Mm-hmm. Sorry, I interrupted you.
She refers to the fact he has a TV, a laptop preloaded with various programs, reading material, notebook for journaling, a CD player and a DVD player. It notes that he's a prolific sender and receiver of emails while he's in his cell. That he has contact with a member of the prison chaplaincy team. He orders his daily meals on the laptop and takes all the meals that are issued to him. That's different from the evidence that was given to Miss Connolly, where it was suggested that he was declining meals for safety fears and having to save up and buy tinned food, etc. The governor says that's flatly wrong. That's paragraph 72. As to social visits, he's having 2 hours of social visits 4 times a week, and it's explained that that's more visits than most prisoners, and that they try to be flexible to manage that time for his benefit. And he has social visits taking place in a more comfortable and relaxed environment than most prisoners do. He has to provide a list of people who might want to visit him, and that's looked at by the prison authorities. Paragraph 80, she says that there have been 120 people so far included on his visit list, and he's received over 80 social visits, not including additional visits from his family. She says that on a small number of occasions, those visits haven't been allowed to go ahead because, for example, concerns that someone coming to visit him was coming in a journalistic role, and there's a particular process one has to go through to make contact with the prisoner in those circumstances.
I wonder if you could keep your voice up, Mr. Erdley.
I beg your pardon?
I can hear you, actually, but I think the court is big and full.
Moving on to telephone calls, she explains that when he first started the segregation, he had 10 hours per day where he could use the telephone. That was then cut to 4 hours because of concerns about people recording his telephone calls and publishing them. It was reduced to 2 hours during that period. It's now, since the 11th of March, it's been increased back to 4 hours. And that's in addition to the contact he has by telephone and in person with his legal advisors. And it's said that since the 1st of November, he's made more than 1,250 social telephone calls. And details of who he calls, including his family members, is given paragraph 87. And she addresses situations in which, according to him, these calls have been cancelled or cut short. Those have specific reasons attached to them, save for a few one-off or very isolated incidents. So you can see very well why Mr. Justice Chamberlain rejected the term being held in solitary confinement, and stuck with the term that comes from the prison rules and orders, segregation, which is in turn defined as a reduction in association. And that's precisely the wording that the judge, Mr. Justice Johnson, used in his sentencing remarks. So we say factually that there really isn't very much difference at all between what the sentencing judge anticipated that life would be like for Mr. Yaxley Lennon in prison and what has in fact transpired. And as to the legal objection for looking at a difference in the actual circumstances in which he's held and what the judge anticipated, can I take you to the case of Watson, tab 10 in the authorities bundle?
Mm-hmm. Yes.
This was a case about medical deterioration. At paragraph 14 on page 178, Your Ladyship made the point that I've already referred to, that the court is a court of review. Then at paragraph 15, it's explained what that means. It considers whether the sentence was wrong in principle or manifestly excessive. It does not, in the light of something that has happened since sentence, consider whether an offender should be sentenced in an entirely new way because, for example, of what has happened in the penal system, or because the offender has supplied fresh information long after the event. So we say that's exactly the zone in which this appeal is located. You then go on to identify some exceptions to that, where there's been some improvement in offenders' behaviour and in the medical cases that I'm going to come to under the next ground.
So it's paragraph 16, isn't it, as it was relevant to this, to the flexibility that's there?
Yes, we say that doesn't assist this appellant. It's not a case where someone has performed beyond expectations in terms of prison discipline, etc. And Your Ladyship makes the point at paragraph 22 and 23 of that judgment that unless an appellant can bring themselves in those exceptional categories, it's really a matter for the prerogative or the statutory power to release on compassionate grounds and not a matter for the court. So that's our case on the comparison between the conditions envisaged and the conditions actually experienced by Mr. Yaxley Lennon. Moving on to ground D now, which is the submission by my learned friends that imprisonment is having a significant impact on the appellant's mental health and more significant than envisaged. We do take a point about delay here. I know it's not possible to identify a fixed point in time where someone's condition has deteriorated to the extent where further assessment is needed. And I accept my learned friend's point that one has to look at the condition for a while to see if it's a permanent deterioration rather than something that might recover. I also accept, although it's not actually in evidence, that there are difficulties at finding psychiatrists and psychologists and getting them into prison to assess prisoners. But nevertheless, there is a degree of delay here. But more importantly, again, it's a question of both the facts and the law. The evidence that the appellant chose to put before Mr. Justice Johnson was just that 2019 letter from Dr. Cutland Green. Which, short though it is, did put him on notice that this appellant was at danger of deterioration in his mental health were he to be held in the conditions that the judge anticipated. And that's then confirmed by Dr. Connolly, who says that it's complex PTSD, which had resolved at the time of sentencing, but not something he had fully recovered from, and that he was liable to have that reactivated by similar causes. So we say that brings him into the A and S line of cases. That's a case where there's a known condition, but then a significant deterioration of that condition post-sentencing. That case is at tab 11 in the authorities bundle.
Yes.
And one can see from the head notes that one is looking here at very serious medical conditions indeed. What's said in the head note is, while a medical condition which may at some identified future date affect either life expectancy or the prison authority's ability to treat a prisoner satisfactorily, may call into operation the Secretary of State's powers of release. That's not, as a matter of general principle, a reason to interfere, but then it goes on to recognise that it can interfere as an act of mercy in the exceptional circumstances of a particular case. And at paragraph 10, we have the Bernard principles my learned friend was referring to, that those direct a sentencing judge as to what they should take account of in terms of a prisoner's health condition. And again, that's reference to either affecting life expectancy or the prison authority's ability to treat a prisoner satisfactorily. It said at 3, a serious medical condition, even when it's difficult to treat in prison, will not automatically entitle an offender to a lesser sentence. But at 4, an offender's serious medical condition may enable a court as an act of mercy in the exceptional circumstances of a particular case, rather than by virtue of any general principle, but to impose a lesser sentence than that would otherwise be appropriate. But then at 17, on page 188, the court poses itself a question: is it proper for this court, that's the appeal court, to take account of medical evidence obtained after sentencing which shows a significant deterioration in a serious medical condition which was known to the sentencer? And the answer to that, having reviewed authorities, is that there is some flexibility to do so. And the conclusion is reached at paragraph 20.
Yes. We'll have that.
You have that.
Thank you.
So the short point here, this isn't a Bernard case, and the court has to have regard to the Bernard principles, even if considering whether to exercise its exceptional powers. But the illness, I don't want to make light of it in any way, but it's not a terminal one, nor is it something the prison authorities can't treat satisfactorily. There's very detailed evidence in Mrs. Marfleet's statement about the degree of attention that the appellant is receiving in terms of mental health, monitoring, provision of therapy, etc., where needed. There's no evidence suggesting that this is a condition that has got so bad it can't be managed in prison. So the proper analysis, we say, is this: the appellant's PTSD has recurred. We don't dispute Dr. Connolly's evidence about that, but that was very much something the sentencing judge had in mind as a real possibility when determining penalty. It's a condition that's being monitored and managed in prison, and it doesn't show that the judge was wrong to sentence as he did, and it doesn't come close to those exceptional circumstances where an appeal court, as an act of mercy, needs to depart from its role as a court of review and disturb a sentence that was correct in law. So that's ground D. But lastly, moving on to ground E, and this is the significance of the diagnosis of ADHD,
Yes.
Which we accept, but wasn't before the judge. We say it's significant that the reason why it wasn't before the judge, the appellant made a choice to plead guilty, admit the contempt on that Monday morning, and to proceed straight to sentencing based on the limited and quite old evidence that his counsel chose to put before the court. He was keen to get on with sentencing, and one can understand perhaps why. He did have the eyes of the world on him that day. But if his counsel had asked the judge, on the basis of that Cutland Green letter, for more time to explore his current mental health difficulties and what that might mean in sentencing, there must be a high likelihood the judge would have taken that application seriously. He could have been looked at that point, and no doubt ADHD would have been spotted at that point. So that's why we take a slightly different approach in terms of fresh evidence as to this part of Dr. Connolly's report, because we say that evidence of ADHD could have been obtained earlier with reasonable diligence. But assuming you're against me on that, and you do wish to look at the ADHD diagnosis and consider what difference it should have made to the judge's sentencing, it's always right that if a defendant has a mental health condition, it must be looked at and considered on sentencing, as Sentencing Council guidelines, overarching guidelines to that effect. And it can impact sentencing in a number of different ways. It may reduce culpability if it's a condition that makes you disinhibited or unable to appreciate the consequences of your actions. It may increase the difficulty of that defendant serving a prison sentence, or it may serve as some wider personal mitigation if it's a condition that's blighted their lives for some time. It's the second of those that my learned friend relies upon, the additional hardship that serving a prison sentence in segregation has for this appellant because of his ADHD. And again, I don't challenge Dr. Connolly's evidence on that, but your ladyship was right to test my learned friend as to whether the difficulties she anticipates have actually manifested themselves in terms of disinhibited or aggressive behaviour, and as my learned friend rightly accepted, the evidence of that is limited to poor behaviour on a couple of telephone calls. But the question for this court is, if the judge had known about this condition, would it have made a material difference to his sentence, such that his sentence, seen in light of that evidence, can now be said to be so excessive that this court should interfere? And we say not. ADHD is frequently cited by defendants in sentencing exercises. My learned friend hasn't put before you any case where a failure to recognise that condition on its own has led this court, or the Court of Criminal Appeal, to find that the sentence was manifestly excessive. It's mentioned sometimes in combination with other circumstances, but he hasn't shown you any case where a failure to appreciate ADHD has itself rendered the sentence manifestly excessive. And here we have a judge who's looking at the evidence about medical effects of incarceration based on the Cutler Green letter, and it's clear that he's taking into account the fact that it will have, or is likely to have, a significantly negative effect. So one questions whether the absence of the label ADHD from her letter really makes a difference, or a difference of the extent to which this court needs to be concerned. And lastly, one does have to take into account that this has been a very significant reduction in the original sentence that Mr. Justice Johnson had in mind. He takes it down from 24 months to 20 months before the further discount for plea. And so there's already been, for the reasons he's given, substantial mitigation, taking into account the claimant's mental health as it was presented to him on that occasion. So for those reasons, we say that his sentencing was an impeccable sentencing exercise with which this court shouldn't interfere. It wasn't wrong, and the evidence now before you doesn't take you into the exceptional category where one has to step out of the reviewing role of the court and indulge a claimant because of merciful reasons and grant clemency. So unless I can insist any further, those are my submissions.
Been very helpful indeed, Mr. Erdley. Mr. Pater, anything to add or follow?
No, thank you, my lady.
Thank you, Alan. Lord Justice Warby just wonders, neither of you have addressed the, I think, the second application for fresh evidence, which relates to the appellant's further witness statement. What is the position on that?
We don't object as long as the prison authorities' evidence goes in. You can take Mr. Yaxley Lennon's evidence and response into account.
Would you have a position on how we should deal with the differences between, as it were, Marfleet on the one hand and the...
well, the difference is very small. Perhaps I can just take you to the witness statement and show you what we perceive them to be. It's in the final bundle, so bundle D, tab 3. Yes. And the regime he describes there, we say, doesn't really... he describes doesn't differ materially, we say, from what Ms. Marfleet says. Mm-hmm. That the number of hours in the cell matches up. He gives a bit more detail about what he does during his time out of cell. Yes. He confirms that he's allocated 4 2-hour social visits a week. He says a significant number of visits have not gone ahead. Well, she says it's 17 visits have not gone ahead, and she gives reasons for that. So no great divergence there. And he says that when they don't go ahead, it's because someone's trying to visit him in a journalistic capacity, which is what she says. He says, my family is usually able to come and see me to keep me company when this happens. So he gets family visits even if other social visits don't work. He says his lawyers can see him in the high security unit on a Thursday. He accepts he's got a TV, but he complains he can't watch GB News on it. And then there's a bit of slightly confusing evidence about the CD players and when they were delivered. We'd be perfectly happy to accept his evidence that he's only received those quite recently. Ms. Marfleet doesn't go into the details of when he got what. He gives a similar account as to his ability to use the telephones. He says those slots for telephone calls don't always happen, but they're subject to change without notice. Well, Ms. Marfleet's explained the extent to which that's occurred and the reasons why. And he adds the detail that he's made an application for release on temporary licence that hasn't, at the date of this statement, been dealt with. So we say, by all means, take this into account, but it doesn't change the picture.
That's very helpful. Thank you. Yeah. Thank you. Yes, Mr. Williamson?
My lady, just a few points, if I may, in response, and perhaps to begin with Mr. Yaxley Lennon's witness statement. It has to be borne in mind, Ms. Marfleet's, or Governor Marfleet's, witness statement has not had appended to it the exhibits. And so you may wish to view her statement as of somewhat reduced weight because you don't have the material underlying it with which to assess her statement. And one of the fundamental problems is that the presentation of Mr. Yaxley Lennon's conditions were contrasted with those of
Just pause a moment, Mr. Williamson.
I apologise.
Yes.
I've just seen what's going on.
Yes.
I'm sorry.
You want us to carry on? We're going to ignore it.
Thank you.
Yes.
He's a civil prisoner, and the comparisons that were made in Governor Marfleet's statement were to convicted prisoners, or alternatively, convicted prisoners who were on segregation. And of course, they are probably on segregation for disciplinary reasons rather than safety reasons. And right it is that the number of hours which Mr. Yaxley Lennon is out of his cell theoretically increases on 3 days a week to 18 hours a day. But I purposely haven't delved into this because I know that this court won't want to engage on a deep fact-finding exercise. But that is dependent on resources. The fact is, as my learned friend accepts, whatever regime Mr. Yaxley Lennon is held under, it has resulted in illness. And that is a structural in our submission when one reads the whole of Dr. Connolly's report. That is a structural position. He's not going to get better unless and until he is released, because it is, and this is of some importance, the absence, not reduction of association, it is the absence of association that is particularly affecting him. I'm sure they're lovely people, but the only people with whom he can speak are those who are guarding him, and that is a qualitative difference from being able to associate with his peers.
Okay.
May I just, and one always with some trepidation, make submissions to a judge as to what might have been in their mind when they gave a judgment in a different case. So I'm going to tread very carefully, if I may. But there are public policy reasons behind the reluctance of the criminal courts to hear evidence as to health that has arisen subsequent to sentencing. And may I venture that is what the court was referring to in Watson when your ladyship said the court cannot be approached with evidence as to health many years or a long period of time after sentencing, because of course criminal sentences extend for far greater periods often than the 2-year maximum which can be imposed for civil contempt. And so the public policy reason, under the Bernard principles, someone must be sentenced and the court mustn't be troubled years later as to health reasons. It is one aspect. The second aspect is that prison sentences serve a different purpose. And that one of those purposes may be bluntly put as keeping people out of circulation, protecting the public. And that is not a reason that applies to civil contempt committal. And so that is why I've urged on this court that the Bernard principles do not need to be applied, or at least do not need to be applied as rigidly as they would for a criminal prisoner. Lastly, if I can read my own writing, in terms of when something may be discoverable and whether his mental health condition should have been brought to the attention of Mr. Justice Johnson, again, if one looks at Dr. Connolly's report, it's evident that he and his family didn't realise that he had ADHD, and I think his mother just regarded it as the way he was, in contradistinction to his siblings. And so to that extent, it may be a bit like a latent issue in other circumstances. One simply doesn't know that one has that problem until a professional sees the symptoms and assists you with that. And so that's why he wasn't able to assist Mr. Justice Johnson as to his condition. even if an adjournment had been obtained, there's no necessity that the psychiatrist or psychologist who saw him then would have spotted those symptoms. He took a specialist such as Dr. Connolly. My lady, my lords, unless I can assist you further, that is...
Me? Thank you. Well, thank you all, both counsel and those sitting behind them, for their very helpful written and oral submissions this morning. You're going to reserve? Happy to... Yes. There's obviously a deal of material for us to consider, as well as submissions of law. So we are not inclined to deliver a judgment today. We will be reserving our judgment both on the applications for an extension of time and fresh evidence, and also any ensuing substantive decision. We will let counsel know in the normal way how and when we will be handing judgment down. Obviously, we know what the timelines are because we've exchanged dates on that, Mr. Williamson. Are there any other particular matters that you would urge upon us in terms of timing?
Thank you. Would you mind my back just for a minute, lady? My lady, thank you. No.
No. No?
But
Thank you all very much indeed.
Court, rise.